Welcome to Law Family. This video is helpful to the law students and newly practicing young advocates only. Today, we discuss about the section 45 and section 46 of BNS Act 2023. Corresponding law is section 107 and 108 of IPC. Abatement. Abatement is a separate and distinct offence provided the thing abated is an offence. Abatement is a separate and distinct offence provided the thing abated is an offence. Important point. Abatement does not itself the actual commission of the crime abated. It is a crime apart. As a general rule, a charge of abatement fails if the substantive offence is not established against the principal. But there may be an exception where the substantive offence was undoubtedly committed and there is evidence such as retracted confession, that is section 24 of BSA Act. Corresponding law is section 30 of Evidence Act. By the abater on which the jury might have found as against him that the offence was committed by the principal through thoroughly as against latter, the confession would be insufficient for a conviction of murder. Abatement constituted. Number one is by instigating a person to commit an offence. Second one is by engaging in a conspiracy to commit it. Third one is by intentionally aiding a person to commit it.
Welcome. Instigation word as used in this section may be an instigation of an unknown person. That a person who, first point, by willful misrepresentation, second point, by willful concealment of a material fact which he is bound to disclose voluntarily causes or procures or attempts to cause or procure a thing to be done is said to instigate the doing of that thing. The offence is complete as soon as the abater has incited, that is, encouraged another to commit a crime, whether latter consents or not, or whether having consented he commits the crime or not. This form of abatement depends upon the intention of the person who abets and not upon the act which is actually done by the person which he abets. Cases. Master's liability. Abatement is a crime apart, irrespective of whether the offence is committed or not. Second, suppression of evidence. Where the accused asked a witness to suppress certain facts, in giving his evidence, it was held that this was an abatement of giving false evidence. Third one is deliberate absence is no instigation. Fourth one is instigation to commit by letter or other ways, that is through phone, electronic systems or cell phone messages. Fifth one, giving bribe. In such a case, even if corroboration is considered desirable, a less strict standards of corroboration evidence may be accepted, as for instance evidence of previous statements and the like. most important point.
Most important point. A mere conspiracy would not amount to abatement, and it would appear that if conspirators were detected before they had done more than discussed plans with a general intention to commit an offense, they would not be liable as abettors. Some more cases: suicide, forgery, abortion, giving false information, abetment of murder.
No abatement.
No abetment of murder. Sorry, no abetment of murder. Lastly, abetment by aid. These are the some more cases. And then section 46 of BNS Act, abettor is the person who abets. One is the commission of an offense. Second one is or the commission of an act which would be an offense if committed by a person not suffering from any physical or mental incapacity.
Some important cases. Acquittal of principal is no bar to conviction of murder. Second point. Second case. Persons giving illegal gratifications under coercion and fear of being harassed are not accomplices. Third, act of humiliation by itself would not come within the ambit of abatement. Fourth, it cannot be said that a person subjecting a woman to cruelty is guilty of abatement. Next case. Abatement of suicide, word uttered in a fit of anger or emotion without intending the consequences to actually follow, cannot be said to be instigation. 2024 3 296 of Supreme Court. This video is purely theory. The Honorable Court decides each case on merits. Thank you.
Thank you.